Good afternoon. And thank you all in the press for joining us today. I'm Congresswoman Yvette Clarke of the Congressional Black Caucus, chair of the Congressional Black Caucus, and proud representative of New York's 9th Congressional District, located in Brooklyn, New York. I want to begin by thanking my colleagues in the Congressional Black Caucus for their leadership, their commitment, and their presence here this afternoon. Earlier today, the Supreme Court began oral arguments in Louisiana v. Caucus, a case that places Section 2 of the Voting Rights squarely in the crosshairs of this court's conservative supermajority. Let me be clear, this case threatens to dismantle one of the last remaining safeguards against racial discrimination in our electoral system, and the stakes could not be higher. We are standing on the precipice of what could be a substantial blow to one of the most important civil rights laws in our nation's history. For every step we take toward building a more and just and inclusive democracy, there are those hell-bent on dragging us 2 steps backward. Republicans are attempting to run the table with every dirty trick in order to cement power because their policies have failed. Combined with Republicans' mid-decade gerrymandering, a ruling gutting Section 2 could help them secure an additional 27 safe Republican United States House seats, at least 19 directly tied to the loss of Section 2. A ruling of this magnitude would have wide-ranging implications. It was not handed over freely. It was fought for, organized for, litigated for, and ultimately won through tireless effort and advocacy by black communities across the state. But now, a group of self-described non-African American voters is turning that hard-won victory into a constitutional attack. They are arguing that the map intended to remedy racial discrimination is somehow discriminatory against them. Their claim, and the simple fact that it is being entertained by the highest court in the land, is not only absurd, but it's dangerous. The opponents of Louisiana's new map and the state itself are seeking to twist this case into a weapon that could gut the ability to challenge racially discriminatory maps nationwide. This is an affront to every community that has fought, marched, and bled for the right to vote. The late Congressman John Lewis said, "The right to vote is precious. It is almost sacred. It is the most powerful nonviolent tool we have in a democracy," end quote. Right now, that tool is under threat. Fair representation is under threat. This is not just a legal fight. This is a fight for the future of our democracy. We will not give up. We will fight. We will continue fighting in the courts, in the Congress, and in our communities against any attempt to silence our voices and dismantle our power. To those who seek to drag us backward, know this: the Congressional Black Caucus stands united. We will protect the sacred right to vote, and we will defend the promise of democracy for every American. It is now my honor to bring to speak at this time the gentleman from Louisiana, Rep. Troy Carter, first vice chair of the Congressional Black Caucus.
Thank you very much to our illustrious chairwoman, Yvette Clarke, for convening this important press conference and for your steadfast leadership on this issue and all other issues. Today, the Supreme Court again heard oral arguments in Louisiana v. Calais, a case that could dismantle what remains of the Voting Rights Act of 1965. At stake is whether one-third of Louisiana's population, my home state, black Louisianians, will continue to have an opportunity to elect representatives of their choice, or whether hard-won progress will be erased under the guise of so-called colorblind politics. For decades, the court's conservative majority has chipped away at this landmark civil rights law. Now Section 2, which prohibits voting practices that discriminate based on race, is on the chopping block. If struck down, Louisiana could lose its 2 majority black congressional districts, silencing black voters' voices in Washington. Critics claim that the VRA is no longer needed, but history and data tells quite a different story.
Absolutely.
Louisiana's colorblind poll taxes, literacy test, and Jim Crow jury laws were tools of exclusion. Further, though black people make up 1/3 of the population, only 5 Louisianians have served in the U.S. House out of 171. That's not equal representation. That's a travesty.
That's right.
Without protections like Section 2, black communities will lose power. Their concerns are sidelined and our democracy is weakened. We've seen what happens when discriminatory systems go unchecked. Louisiana's non-unanimous jury rule, born of Jim Crow era state constitution, stood for over a century until black lawmakers, for which I was proud to be a co-sponsor of that bill when I was in the state Senate, finally changed its deep racist roots. That's power, and the necessity of representation remains strong. We must be at the table. We must have a voice. The Voting Rights Act once united lawmakers through both parties. In 2006, it passed Congress without a single dissenting Senate vote. We need that spirit again at the Supreme Court and amongst our Republican colleagues. Back in March, I had an opportunity to visit Selma, Alabama, with my dear sister, Terry Sewell, and many others. Congressman Jim Clyburn, Chairwoman Clarke, and many other members of Congress were in that number. We walked across the very bridge where John Lewis and Amelia Boynton were beaten to forge a more perfect union. 60 years ago, their blood gave birth to the Voting Rights Act, and we must not let that sacrifice be in vain today.
That's right.
This is a defining moment. This is our civil rights moment of 2025. Americans can honor its democratic promise, or it can retreat to the past, where some voices simply were not heard, or at a minimum, didn't count. Section 2 is not a relic. It's reality. It's as needed today as it was in 1965. Some might even argue that it's more needed, because we see the attempts under this Project 2025 to reverse the actions of gain, to take away the freedoms and the rights of Americans. Some today, others tomorrow. We must be united to push back against this attempt to destroy our democracy, to undo laws that have given protection and fairness to the American people. Congressional Black Caucus is leading that way. We stand firm in this defining moment. We stand firm saying that it is a living promise that this democracy belongs to all of us. We must defend it in Louisiana and across the country, because this is our battle. Regardless of your race, your background, your zip code, or your socioeconomic status, we are in this together, and we are not going to retreat.
All right. Thank you.
Next, I'll bring up the esteemed leader from Alabama, Representative Terry Sewell.
Good afternoon, everyone.
Good afternoon.
I'm Congresswoman Terry Sewell. I proudly represent Alabama's 7th District. It includes the historic cities of Birmingham and Tuscaloosa and Camden and Marion and my hometown of Selma, Alabama. I am also the lead sponsor of the John Robert Lewis Voting Rights Advancement Act in the House of Representatives. I want to thank the CBC and our illustrious chair for her leadership at this moment. We are 62 strong. And we are only 62 strong because of the Voting Rights Act of 1965. We must do everything in our power to make sure that it is not stripped and ripped from the pages of our Constitution and our laws. It's simply a must. For the past decade, extremists at every level have waged a concerted effort to make it harder for certain Americans to vote. They've passed hundreds of new laws restricting access to the ballot box. They've gutted key provisions of the Voting Rights Act of 1965, and now they are back in the Supreme Court trying to legalize discrimination against black and minority voters. The stakes couldn't be higher. For decades, Section 2 of the Voting Rights Act has served as a critical tool to fight back against discrimination and to ensure that minority communities are fairly represented. For so many of us here today, Section 2 is why we stand before you as members of the Congressional Black Caucus. If this court strikes down these critical provisions, it would not only reverse decades of precedent, but it would also take us back to a dark time in our nation's history, a time when discrimination against minority voters went unchecked. We in Alabama are no strangers to this fight. Just 2 years ago, the Supreme Court actually upheld the protections of the Voting Rights Act when it ruled that the state of Alabama intentionally discriminated against black voters. That was a major victory for fair representation. It was an acknowledgement that the Voting Rights Act is alive and well. That was only 2 years ago.
That's right.
But the fact that they are now taking up a single question in the Louisiana versus Calais case is truly disturbing. What is that question? Whether majority-minority districts violate the 14th Amendment Equal Protection Clause and the 15th Amendment, the right to vote being unabridged by race. This cuts at the heart of why we love the Voting Rights Act and why it's considered a seminal piece of legislation. The Voting Rights Act gave us a tool by which we could show the effects of voter discrimination.
That's right.
Now, in Shelby versus Holder, they took away Section 4 and 5 by telling us that we in Congress just rubber stamped those same 16 jurisdictions over and over and over again. And they said that we need to show modern day forms of discrimination. Well, the Voting Rights Act, the John Robert Lewis Voting Rights Advancement Act, looks back 25 years, not 60, not 40, 25 years. And still we see state after state after state violating minority rights. We look no further than Louisiana, North Carolina, Texas. We look no further than Alabama. But I'm here to tell you that our fight is worth having because when we win, all of us win. We won in the Milligan case, and now I have a colleague by the name of Shamari Figures who stands proudly with me as a part of Alabama's congressional delegation.
That's right.
That wouldn't have happened without a legal fight.
That's right.
And I know many of us are lawyers here, and we know that we've got the freedoms that we enjoy today often because of litigation. But we also know that all of us have a role to play. Litigators need to litigate, and that's what they're doing. And I have to say, I was proud to sit there in the Supreme Court all 2.5 hours listening to that oral argument. I couldn't have been prouder of Janae Nelson, the executive director of the Legal Defense Fund. I couldn't have been prouder of all of the lawyers from the ACLU and the Southern Poverty Law Center and the National Democratic Redistricting Committee. They all have done a great job. But what was clear in the questioning of the majority on the court is that they have something in mind. They have, within their cause, to claw back Section 2, if not to eliminate it totally. And we cannot and must not let that happen. This case is more than just about congressional maps. It's about who we are as a nation and what we want our democracy to be. Now, I may be the first black congresswoman from Alabama, but I damn sure won't be the last.
That's right.
And we're going to ensure that by standing firm and standing tall. The case law is on our side. 2 years ago, the Milligan case said Section 2 is still alive and well.
Yes.
It didn't say it was unconstitutional. So we have to stand firm and stand tall. When all of our voices are heard and counted, we all benefit. But if states can pick and choose which voters to silence, none of us are safe.
That's right.
We all have a role to play, and we in the Congressional Black Caucus will always stand firm. You know, year after year, when John was alive, I had the great honor of bringing delegations to Selma, year after year after year. Many of us had the opportunity to walk in the footsteps of John Lewis with John Lewis.
That's right.
So did our Republican colleagues. They need to be reminded that it was not just simply a walk across the bridge or walking in the footsteps of a legend. It was about the promise of what this country can and should and must be. And we all have it within our cause to make sure that this is not just a promise unfulfilled, but it is a promise that we can make and keep, all of us. Let's get into some good trouble. And let's remember what John said on that bridge the very last time he was in Selma. He was riddled with cancer. It was literally 2 months before his death. But we took John to the apex of the bridge like he normally is, and we stood him up, and with a very strong voice, he said, "Never give up, never give in, keep the faith, and let's keep our eyes on the prize." CBC members, let's continue to get into some good trouble. Yes. Good trouble, necessary trouble.
Yes. All right. Yes. Right. We will now hear from Rep. Glenn Ivey of Maryland.
Well, I want to thank you, Madam Chair, for pulling this together on behalf of the CBC, and our Vice Chair for work that he's done on this, and all of our CBC colleagues. I'm originally from North Carolina, from back in the 60s. I can remember when the civil rights movement was going. I remember when these pieces of legislation passed, not because I was watching what was happening on Congress, but because I remember how it transformed our lives on the ground. The Civil Rights Act, the Voting Rights Act, key pieces, but the Voting Rights Act was the crown jewel of that civil rights legislative achievement. And it's made a difference across the country over the decades. In 1987, I came to work as a staffer for Congressman John Conyers. I think we had 21 members of the CBC then. The Voting Rights Act was starting to kick in, but it hadn't got all the way there. But as you heard a moment ago, we've got triple that now. 62 members of the Congressional Black Caucus. And other caucuses like the Congressional Hispanic Caucus have also benefited from the impact of the Voting Rights Act. We've got to make sure that we keep these protections in place. These were hard-earned, and they've been transformative to the American democracy in a positive way. Malcolm X once said that what they do is they try and make it so you can't vote, but even when you get a chance to vote, then they try and fix it so you ain't got nobody to vote for. So we've got the combination of those two things going right now. We've got them trying to fix it so we can't vote. After they struck down the pre-clearance provision of the Voting Rights Act several years ago, states in the South in particular started passing little laws to nibble away at the ability, especially for minorities, to vote, because they saw the growth in our participation and the growth in our representation. That hasn't worked, so what's Trump trying to do now? Now he's trying to do the mid-decade gerrymander to try and undercut us from winning in that way too. We can't allow that to happen. I know it's a Trump Supreme Court. I know he picked 3 of the people that are there. But as you heard a minute ago, 2 years ago, they got it right. There's absolutely no reason, no legal reason, no historical precedent reason that should change now. And those 3 people that he put on the court all promised to protect important precedent when they got to the Supreme Court. This has been affirmed over and over again, Section 2. And as you heard a minute ago, it used to pass in the old days almost unanimously. You might have Jesse Helms holding out or Strom Thurmond holding out, but we knew why they were holding out, because they were carryovers from the Dixiecrat era. Now, it's grown. But we've got to make sure that we fight back, protect the Constitution, protect the gains that we made, protect the representation that the people themselves have decided they've wanted, and make sure we keep the Voting Rights Act intact and moving forward. So thank you so much, and we'll keep up the great work.
Thank you. Thank you, Glenn. And we will now hear from Congresswoman Sheila Sheffield McCormick of Florida.
Good afternoon, everyone. I'm Congresswoman Sheila Sheffield McCormick, and I represent the great state of Florida. Many people don't realize that the case that the Supreme Court is hearing today actually affects us all, especially in the state of Florida. In the state of Florida, we already have a state legislature who already whitewashed our history, now making our black history seem like it's non-existent. But they're doing that so they don't have to face the real reality. I ask everybody to walk into my district, where we still have walls of segregation that remind us of what we've gone through. We still meet at Mount Hermon, which is the church that we actually met before, and we talked about how do we leverage our political power. We still talk about how we're able to vote without worried about the governor's police force who's looking for voter fraud. That's the reality that we live in every single day in Florida. So when we hear this case, we know what this is really about. It's about now whitewashing our votes, now suppressing our votes, suppressing us as our people and our voices, of how we suffer, of how we always try to compete and to strip back the remnants of racism that still exist in Florida today. But Florida's not alone. The South sees this every single day. So as the Supreme Court hears this case, and they try to argue that it's no longer necessary, I encourage everyone, come into my district, see what we see every day. Walk in our footsteps so we could tell you about historic Sis-Trunk that was burned down, that tried to stop people from voting. Come see who we are and who we're fighting to be, and you'll understand why the Voting Rights Act is not just necessary today, but also for our future, to give us an opportunity to finally realize the American dream of justice for all, despite your background. We know what this is really about. This is about stealing and netting 20 to 30 seats. Yes. That's what this is about. It's not because they believe that racism is gone. It's because there's an election coming and they know they're going to lose. They have made the Voting Rights Act just another tool in their pocket that they want to eliminate so they can have a free-for-all and drive us closer and closer to a dictatorship. And I know firsthand what a dictatorship looks like. And this is where we're heading if the Supreme Court does not stand firm and acknowledge the need for the Voting Rights Act and the need to make sure that every voice is uplifted. So I applaud the chairwoman, I applaud Terry Sewell and everyone who has been fighting for this, and I applaud every single American who is paying attention, and I thank the media for being here to show everybody what's really going on so we can get away from the distractions of what the White House is doing today and tomorrow and every other day, and do what the American people need, which is be here and fight for them. Thank you so much.
Thank you. And then we will have Al Green of Texas to close.
Thank you. Thank you, Madam Chair, and I thank all of the members of the CBC, Vice, and others. I was born in Louisiana, Charity Hospital. I live in Texas. I was present when Bush, the son, signed the Voting Rights Act extension. I'm currently litigating against the state of Texas for invidious discrimination as it relates to Section 2 of the Voting Rights Act. I have a sense of what this is all about. The Supreme Court has said, if it's political, if you're gerrymandering for political purposes, that's okay. The question becomes, how do you prove that a person who is doing it for racial reasons, how do you prove that that's what's happening? That's the question. And if you assume that there is no longer racism in this country, then you have to understand the history. Racism still exists in the United States of America. Racism was the reason my people were brought here.
That's right.
We were brought here to be a permanent, identifiable, subservient caste of people. Caste, not class. Class is socioeconomic. You can move in and out of it. Caste, you were born in it. As a baby, you're a slave. You live in it as a slave, and you die in it as a slave. When the Civil War ended slavery, it didn't end the root cause of it, which was racism. It then metamorphosed into something called convict leasing. That lasted for approximately 100 years. We ended convict leasing, but we didn't end the root cause of it, which was racism. We then had something called lawful segregation. Lawful segregation, which ended with Brown versus the Board of Education. When we ended lawful segregation, we did not end racism, which was the root cause of lawful segregation. So we find ourselves today with the Supreme Court having to make this decision. Does racism still exist in the United States of America to the extent that we need a Voting Rights Act to protect people of color, not just black people?
Yes.
All people of color are subject to the same invidious discrimination. And at some point, we have to take a stand together. I'm so proud of what the LGF is doing, but we've got to take a stand together. And here is the final word that I have for you. We cannot allow the gains that people lived and died to acquire to be eviscerated by a Trump Supreme Court.
That's right.
We have to understand that while the Supreme Court may render a decision that's antithetical to our best interests, they don't have the last word.
They do not.
We are the we and we the people.
That's right.
We have the last word. And we are not going to take this lightly. We are going to do everything that we can lawfully, litigation, but also protestation.
Yes.
These two things are running in concert with each other, in tandem with each other. It is important for us to understand that this battle is one that's been fought since our arrival in this country, and we cannot abandon it now. It's our watch. You are right, dear brother. This is our watch. We can't let it go on our watch.
No.
We've got to pass the torch on to the next generation with a Voting Rights Act that will allow us to be elected to Congress, because many of us are about to leave, and I'll leave with this. I'm one of those persons whose district has been moved to another county. No black person is going to win that seat. I can prognosticate that. No black person. So there's going to be one less black person in the Congress of the United States because of President Trump's desire to have additional seats, notwithstanding the fact that the Voting Rights Act is still needed. There will be one less from Texas, but Texas is not the end. Texas is but the genesis. The revelations are yet to come.
Thank
Good job,
you.
brother. Good job. Good job.
Are there any questions?
Congresswoman, could you take us through the specific legislative priorities and constituent services, particularly among the black community, that could be endangered if the court strikes down the VRA, both short-term and long-term?
Just about all of them. I mean, this is about representation. We know what the role of members of Congress is, and those members that represent communities that have elected them, that are of African descent, that are minority across this nation, will not have that representation that comes from their own lived experiences. So legislation that is reflective of their dreams, their desires, their aspirations will not come across here in this body. And so that's essentially. Would you like to?
Yeah, I just want to double down on exactly what the chairwoman just said. If you accept the premise that we have a representative form of government, that suggests that every part of our country has a voice.
That's right.
If you strike down Section 2 of the VRA, we will not have a representative form of government because some voices will not be represented.
Yes?
Based on whatever happens today, based on the decision, will you need to rewrite any of the John Lewis Voting Rights Act before you bring it up?
That's a great question. Clearly, the question was, in light of what this decision may be, and we won't know this decision until June, probably, will we have to rewrite the John Robert Lewis Voting Rights Advancement Act? And we are working with our partners, our allies, our lawyers, to look at it and relook at it to see how we can strengthen Section 2 as well as reinstate Section 4 and 5.
Forgive me if I misunderstood what you said at the end there. You said your district got moved to a different county. You don't believe a black person can win. Forgive me if I'm totally wrong about this. Are you saying you don't have hope of winning re-election, of representing your district in the future? Is that what you're saying? I just want to make sure I understand what you're saying.
to be very specific, perspicuously so. I never said that. What I said was there will be one fewer, one less person of African ancestry from Houston, Texas. I have been blessed to be in the 9th Congressional District. The new lines do not require that I move to run for a congressional seat. They moved the 18th Congressional District to me. I don't have to move to the 18th Congressional District. I have said I will be on the ballot, but I haven't said what I'll be running for. I said I'll be on the ballot. But it makes sense that I would run from the area where I happen to live, where 70% of my constituents are. The 18th Congressional District is composed of about 70% of the people that I currently represent. I will be on the ballot, and I'll announce it. Well, thank you. Thank you. But I hope that satisfies your curiosity. Thank you.
We've heard concerns that the Supreme Court strikes down this case, that we could be looking at a permanent Republican majority. Does that seem likely? Are those
Certainly possible.
Well, I mean,
It's theoretically possible.
Right.
racial polarization in voting is alive and well. I think that I represent all of the people of Alabama's 7th Congressional District. But there are some people who won't vote for me because I have a D behind my name and because I'm a black woman. That is just the reality and the fact. And so what was said today as a part of the oral argument, one of the justices said, so without Section 2, what do you think will happen? And the response was, it will be devastating to fair representation across America. We are a representative government, and some voices will not be represented, and it's simply antithetical to our democracy. So I believe that that's true, and I do believe that we will see the Voting Rights Act literally changed the face of electoral politics in America. From the mayors, to the city council, the county commissioners, to the members of Congress. It changed the face. Yeah. And it gave a voice to the voiceless. And so what's at stake is us going backwards and not continuing to move forward. And it's a scary proposition. And I have to remind myself every day of John's quote, ours is not the fight of one day, 1 week, 1 month, 1 year. Ours is truly a struggle of a lifetime. And we in the CBC plan to stand firm, and because I know that the law is on our side. Yes. I mean, how it was presented today by LDF and ACLU, brilliant lawyers who made the case why current law and precedent is on our side. The need to even revisit this in light of Milligan 2 years ago, it just shows you where this court wants to go. And just like we were pleasantly surprised in Milligan, I pray that we're pleasantly surprised in Calais. But win, lose, or draw, we will not give up.
That's right.
We come from a strong and a persistent and a resilient people. And we will continue to fight for what we know is fair. And having a voice in this democracy, all of us having a voice in this democracy, is critically important.
Okay, well, thank you very much, everyone. Thank you.
Great job.
Yes.
Can I ask you a brief question? I am a journalist.
Hey, Chris. Tori and I are going to do something on the set.